Hey folks, I'm back. And today I'm talking about a subject matter that comes up all the time in my office, and that is, are my child statements admissible in court? And generally speaking, the answer is no, your child statements are not admissible in court. The court generally doesn't take testimony from a child that is under the age of 15, 14 on the younger end, and some courts don't consider testimony from the child at all. Court might take a younger child back, or a judge might take a younger child back into chambers to talk to them, but this is not testimony. It's more getting a feel for how the child feels about the situation. And some judges refuse to do that at all, or include the child or minor children as a part of any kind of adjudication. But if you feel that your child's statements are material to your case and need to be included in the adjudication, there are options available. The court can appoint what's called a child advocate or a best interest attorney on your child's behalf. That best interest attorney represents your child and your child's best interest, and can actually put on a case for your child simultaneously as your attorney and the other parents, your co-parents attorney, are also putting on their case. Your child has their own attorney. That best interest attorney will inspect the child, will interview both parents, will interview material parties to the case, and will make their own determination as to what is in the child's best interest. The court can take that recommendation or not, but it does in effect give your child a voice, because that child advocate or that best interest attorney is listening to what your child wants and what your child needs as they are presenting it. A best interest attorney is required to make an independent assessment of the child's best interest and to advocate for that determination, even if it's not what the child actually wants. The court can also appoint what's called a child privilege attorney. A child privilege attorney is appointed purely for the purpose of determining whether or not privilege should be waived with regards to the child's medical or psychiatrist notes, psychological treatment records. Neither parent, neither party to the case can waive that on the child's behalf, because they are both part of the litigation. So a child privilege attorney will assess the situation, make contact with the therapist, and make a determination as to whether or not privilege should be waived and those records should become admissible. Statements in those records might be exactly what you're trying to get into court. So are your child's statements admissible? Generally not, but there are tools available for you to use with regards to getting statements from a child in during a trial, during a family law case. Mainly your best interest attorney or your child privilege attorney that can make a determination as to whether or not those statements should be allowed. Thank you for tuning in. I look forward to seeing you again. If you need help with these subject matters, family law, trust and estates, business law, we're here, SA Stevenson Law Offices. The number's here on the screen, 301-795-2728, or find us online. I look forward to seeing you again.